Thank you.
SJC-11103, New England Cafe versus Clerk of Suffolk County Superior Court of Criminal Justice.
Yes, ma'am. Good morning, counsel.
Good morning. May it please the court, Randall Ravitz for the defendants. With me is Thomas Ralph. The court below erred in ordering relief from impoundment because it found for the plaintiffs on their one claim for relief based on a balancing of interests in which the government's compelling interest in protecting an ongoing investigation established by affidavit was found outweighed based on allegations of the plaintiffs that the court accepted.
Well, the court said, though, that the having read the affidavit, that it wasn't, in his view, wasn't going to impede the investigation.
Well, we would say that the court overlooked certain critical things in the affidavit that established good cause. I first want to make clear that this is an ongoing investigation involving multiple targets, so not just the plaintiffs here. And that's something that we think should permeate the analysis. Looking at the affidavits, and this is outlined in greater detail in Mr. Ralph's own affidavit, information that could be gleaned from there but not otherwise include things like what technology was used by undercover investigators clandestinely so that targets could look for it and thwart their effectiveness. The affidavits would give them enough to figure out potentially which former patrons were actually undercover investigators and which employees they interacted with, so that the undercover investigators could be noticed in the future and the employees could potentially be influenced. How investigators learned the identities of personnel so that that could be avoided in the future. What steps were taken by the investigators outside the businesses? So we disagree with the judge's conclusion that all of the activity involved there was undertaken in the business. What investigators thought about the utility of certain evidence, so in other words, their mental processes, their work product, and which conduct occurring out in the open was deemed significant by investigators. So in other words, what type of conduct is there that somebody trying to thwart an investigation should shield in the future? And then finally, what investigators do not know or have not yet done. So in other words, what are the areas of vulnerability in our investigation?
So let me ask you this. I mean, you're not disputing that the judge could order the disclosure of these affidavits after conducting the balancing test, are you?
No.
You're just saying he got it wrong.
Right.
Abusive discretion standard? What's the standard?
Abusive discretion or error of law. And as far as errors of law, we would say that the way that this was handled procedurally included a number of errors of law, but also that a number of the conclusions that the judge reached in balancing the interests, specifically on the plaintiff's side of the interests of the balancing scale, reflected errors of law. So in other words, the judge found them to possess 4 different constitutional rights, 2 of which they never asserted, 3 of which they don't defend now on appeal, and the last of which is the one that they focus on is far from being clearly established. The judge also concluded that there was plausible doubt about the extent to which the criminal statutes apply to the conduct here based on something that he read into a press release by the Attorney General's office concerning 93A regulations. And finally, what the judge focused on was the extent of their business harms and their urgent need for the affidavits. And we'd say one, as far as errors there, one, the judge assigned weight to allegations that they made that were not established, they were not supported by affidavit.
Well, let me just ask you this on that, and you make a point of that. Well, nothing established that their businesses were closed down. I mean, are you really disputing that?
Well,
that would be so easy to check whether they were or weren't.
If we were filing an answer today, we would say that we're without knowledge or information and therefore deny whether the business as a whole is shut down. In other words, whether there is anything else being done by the business. These are businesses that are alleged to be conducting gambling operations. It's not so crazy to suggest that maybe something else is going on behalf of the business that we don't know about. But also,
Is the cafe open or isn't it?
as far as we know, the buildings that we're talking about are not open. As whether the business has been shut down is something else. But there's a few other things related to that. One is that we affirmatively dispute that the businesses are closed because of the searches in the sense that they would otherwise be up and running because of the 93A regulations. So we'd say they'd be closed anyway. Also, it would seem that the judge took into account a number of specific allegations that they made regarding business injury. So in other words, they said 9 employees are now out of a job, and we still have to pay bills on the property even though we don't have income coming in, and we've suffered reputational harm. But they offered nothing to show that those allegations are actually true. The reason why a business being shut down matters is because of those things, because people are out of work and they still have to pay bills.
Let me ask you something. When you were arguing before the judge, did you ever point any of these things out to the judge?
Yes.
That you didn't have these things verified by affidavit?
Yes.
And
yes.
that they needed to be?
Yes. We raised the affidavit issue in pretty much everything we filed.
So let's back up here a little bit. I certainly understand your view that this should have proceeded differently. But let's go back to the balancing. You agree there has to be a balancing. This is an impoundment order, and impoundment orders are sort of presumptively not forever, and you have the burden of demonstrating your interest outweighs the other interests in public disclosure. Why is the judge wrong in his balancing here?
The judge is wrong in his balancing because...
Could the judge ever be right? Is your view that no judge could ever come to this conclusion looking at the material before him?
No. We are not arguing that search warrant affidavits must always be impounded, and there can never be, people like these plaintiffs could never prevail in challenging them. What we are saying is that here, if you think of the balancing as a scale, okay, as far as our interests, the government, the court correctly found, we'd say, that ordinarily and presumptively the government has a compelling interest. Now, that's significant because ordinarily a compelling governmental interest would trump even a constitutional right. And other courts have also found that with regard to ongoing investigations. And again, if you take into account the fact that there were certain things in the affidavits that the judge overlooked, we should still be found to have this compelling interest. And so it would be hard for plaintiffs, it would be hard for a court to conclude that there's any set of interests that would trump that. And then when you look at the other side of the scale, what the court found here, again, you had the four constitutional rights that we say don't exist. There's the doubt about the applicability of the laws based on the press release, and then there's the allegation of the business injury. So that, and then combined with the procedural issues, the affidavits and so forth, and the fact that we hadn't answered, we hadn't formally filed a pleading.
Let me ask you a question. What was the gap in time between the search and the bringing of the indictments against the plaintiff?
The search, the warrants were executed on or about March 31st. The plaintiffs were indicted during the course of this appeal on October 27th.
Is the standard of review an abuse of discretion, or is it a de novo standard?
Well, normally it's abuse of discretion or error of law for impoundment issues generally. What we said is because relief was awarded here preliminarily, so in other words, but prior to the a full adjudication, that this court, based on precedent, can give its own look, essentially a de novo review to the.
But there was no evidence presented, no testimony presented.
Correct. There was a hearing, a non-evidentiary hearing.
Okay.
But
Oh,
Mr. Ralph's affidavit.
right, in the affidavit that we supplied, yes.
Why is it impoundment preliminary? I mean, once it's made public, it's made public. It seems to be a final order.
Right. We would say that this particular order was, well, I can answer that two ways. One is that under Republican, an impoundment order is technically always interlocutory. It's never final. But that's really separate from why we say this is preliminary. We say this is preliminary.
But we mean once it's been publicly released, you could, I guess in theory you could. It seems the cat's out of the...
I'm sorry. No, I meant an order to keep something
Oh, no,
impounded.
okay, that I understand to be interlocutory.
Yeah. Right.
But
Okay.
once you say it's public, it seems a little bit hard to take it back, doesn't it?
Yes. Yes, true. We say this was preliminary because it was prior to a full adjudication. So it's
But in an impoundment proceeding, I mean, it's a little bit sui generis because time is of the essence. So, I mean, do you think the judge gave you time? He said, I want to look at those the search warrant affidavits. He took the affidavit of Mr. Ralph. I mean, it's not clear. It seemed to me that what he was doing was ruling on the merits, and that he had indicated that he might very well do that.
well, as far as what's required and the fact that it's sui generis, this court's quote proper procedure called for the maintenance of a civil action, and so it should be governed by the rules of civil procedure. There's no indication in any of the decisions that, well, it's a civil action, but it's not really a civil action. And if so, if that's what the court had in mind in Republican, then that's not made clear to lower courts or to defendants, and it would create a lot of procedural uncertainties.
Are you saying that you didn't have notice? I mean, he did say, I may well do this on the merits. I want to see the stuff.
What he said was, I will either decide this on the merits or have further proceedings. And we reasonably interpreted that to mean he would either deny their request or have further proceedings, because like a motion to dismiss, you can deny it if you find there's no way they can prevail, but you can't order relief for the plaintiffs where the other side hasn't formally taken a position on all the allegations and they haven't offered anything to show that what they want the court to accept is actually true. So that was, and it was based on also our reasonable understanding of the civil action requirement, which we say could be easily harmonized with the uniform rules, with the allocation of the burden, with this concept of special expedition.
Let me just ask you this. Is there a footnote, is it in Republican that suggests in this kind of situation that actually it would make sense to have the judge who issued the warrants consider the motion to unimpound? Isn't there I may be wrong in my memory.
That, I don't recall that.
Okay, all right.
And I'm sorry if that's
Well,
my
no,
error.
I'm sure that it's probably not your error, so don't assume that at all.
Now, in these cases, is there any middle ground whereby a court can say, I don't wish to impound to make available to the public, but I do wish the party searched to have the opportunity to see it so they can challenge?
The court could do that, and that's very close to where we are now in that once they were indicted, we filed a motion in the appeals court for leave to provide them with copies of the affidavits, but keeping them otherwise impounded.
But not
So
Mr. Ralph's affidavit, right?
I'm sorry, say that again?
Not Mr. Ralph's.
Right, correct. And
But I gather you opposed even a production to them until indictment.
yes, until indictment, right. Which again, we wouldn't say is necessary. We wouldn't necessarily take that position in every case, but where there's an ongoing large-scale investigation involving multiple targets, we're still in the process of investigating. We do believe that the materials are revealing. Then in those circumstances, that's why we're not inclined to see the materials released to them at that point.
What was left to be adjudicated in this case? I mean, were they seeking the return of the money?
They were not, no. What we would have liked to see is a full adjudication of the allegations that the court seemed to rely on. So for example, again, if there's a balancing, what was there on the other side of the scale to convince the judge that it's safe to accept what they're saying is actually true? So plus, if it had proceeded further, we would have made further argumentation about these constitutional rights that were recognized by the judge, because as we said, a couple of them were not even invoked by the plaintiffs. So we wouldn't have argued them.
To
Let's
what
say we-
extent, I'm sorry, go ahead.
To what extent did the fact that there had not yet been indictments factor into the balancing? I mean, it's conceivable that a search of this sort could happen and then no indictments ever. And meanwhile, business, let's take for the sake of argument, is shut down, and, you know, the Attorney General has achieved its goal of shutting down the operation, but no indictments. At what point then, I mean, I don't know what to do with that factor. I mean, was there some assurance that indictments were coming?
The benefit of the good cause test is that it takes into account all relevant factors. So if, for example, things had gone on longer, if we couldn't say, you know, there's a grand jury investigation going on now, if we couldn't say that, for example.
And you were able to say that?
Yes. That would be a different situation. There's also in the various legal principles that we cited, there are generally some sort of exceptions in all of them for situations where the materials aren't going to be used in a criminal prosecution. There really is no prosecution or investigation pending. In Republican, for example, I think it was Republican, where
Father Levine.
years went by.
2.5
It was
years.
years later, so it was safe to conclude that. And we're not saying that it has to be a matter of years. We're just saying that a court can take into account the circumstances showing that there's really no more need at this point.
Could I ask you one last question? And let's assume we agree with you completely. What happens now? They've been indicted. You've made some disclosure of the affidavits to the lawyers or lawyers and parties, or what?
Just to be clear, we obtain leave
Right.
to provide it to the lawyers.
Just to the lawyers?
Yes. But then this issue arose of to what extent can they disseminate it? So I think both sides seem to be of the view that if materials are impounded, generally there's an expectation that they will not be widely disseminated. I'm not saying we reached an agreement on how they could be treated, but we both seem to be proceeding from that assumption. So we sent them a letter saying, here's our view, here are the sources supporting it. Please let us know if you're willing to agree, or if you have contrary authority, or you think it needs to go before the court. And we haven't heard anything back. We got no response to that, and that was over a month
Again,
ago.
let's say you win, and we conclude that the judge used the wrong factors and didn't strike the right balance. What happens now that they've been indicted? These remain under an impoundment order?
Yes, we would ask that this court that the order below be vacated, that there still be an impoundment order. So, in other words, to keep the public from accessing the documents and other targets from accessing the documents. And then we would need to resolve this issue of dissemination by the plaintiff's counsel and whether they can do that to other people. And
As what? As a matter of discovery in the criminal case, or as a?
well,
Can they file a civil action to return, have the $109,000 returned?
we would say that any action that they would bring would be barred by some principle stating that that would preclude that kind of relief where there's an ongoing criminal prosecution.
And so that would constitute a waiver of the statute of limitations on your part.
I hadn't thought about that, but that may be the case. That's just something that I'm sorry I haven't contemplated. But there was, I think there was some part of the
Don't
question.
go into a new topic,
that's okay.
please. It's time to stop.
Thank you.
Your time is up.
Thanks.
May it please the Court, Jeffrey Pyle for the New England Internet Cafe, LLC, as well as the other plaintiffs in this case. With me at counsel table is my partner, Jim Lawson. Judge McDonald did not abuse his discretion in lifting this impoundment order.
But would you agree that he factored in some things that really shouldn't have been factored in? These constitutional rights that really aren't relevant?
Well, Your Honor, the judge's primary focus, as far as those constitutional rights are concerned, I would submit, was on the Fourth Amendment question. The protection against unreasonable searches and seizures and the promise that warrants shall issue upon probable cause.
So that's the amendment you say is still in play.
We certainly rely on that. I also do not think that he was in error in citing due process principles. In fact, there's a slightly analogous case that this court decided in 2010, which the Commonwealth cites in its brief, the Commonwealth versus 2004 Audi sedan, suggesting that there must be a right between the initial drug forfeiture seizure to challenge the probable cause determination behind that and the eventual trial. There must be some opportunity for a party whose property has been seized to challenge that exercise of government power. Here we rely on the same principles to suggest that a party whose property has been searched has a right of access to that search warrant affidavit. And certainly
A constitutional right of access.
a constitutional right of access.
While the investigation is pending.
Yes. And, however, what Judge McDonald's decision rested on was the proper balancing of the good cause standard, and into which he factored some of these constitutional interests. And in doing so, he certainly recognized that these are presumptively public documents once they are filed in court under both common law and by statute. And if they were to be impounded, it was the Commonwealth's obligation to come forward with good cause for impoundment. That amounts to a rigorous presumption of openness, as this court has called it in the Sharp case. And if the Commonwealth didn't come forward with a sufficient reason, then the presumption of openness, the principle of publicity, as this court has called it, has to prevail. And
What about the ongoing investigation?
The mere fact that there is an ongoing investigation has not been held by this court to be sufficient to overcome the principle of openness. In the Republican case, there was an ongoing investigation, and this court reversed the appeals court, which had held
Yeah, but
that
that's an ongoing investigation for about 97 years.
about 30, Your Honor, and so not that far off. So yes, and the length of time that that investigation had been ongoing was one factor in Republican. But then in the Bishop case, decided just a few weeks ago, this court also said that once a document is filed in court, it is presumptively public, quote, even if it sets forth the results of an investigation.
Yes, but then we sent it back for just this question, correct?
Pursuant to the statutory regime. As my brother pointed out, the good cause balancing test allows a Superior Court judge to weigh all these considerations and weigh the nature of the investigation and the actual interests involved. The mere statement that there is an ongoing investigation, there may be some cases where ongoing investigations are of such a nature that release of this particular affidavit will harm the investigation.
Didn't they say here that there was a grand jury investigation, not just an ongoing investigation?
Your Honor, at the time of Judge McDonald's order, there's nothing in the record to suggest that the grand jury had been convened as of that time, to my knowledge.
And nothing was argued about that? That was not before the judge?
No. As far as I know, the grand jury, there was no grand jury going on at the time that this was before the judge. The judge's order makes no reference to any grand jury proceeding. And certainly, these are presumptively publicly filed court documents. We're not talking about the release of grand jury transcripts or confidential grand jury materials. We're talking about public court documents.
Can we review this case de novo?
No, Your Honor. This is an abuse of discretion standard under how this court has handled these matters in the Republican case, and many other cases have said this is an abuse of discretion standard. And in weighing, and that's appropriate given the fact that this is a balancing test, the court looked at what these affidavits said. These were the observations, as Judge McDonald's order reveals, these were the observations of two undercover police officers who went into a public place of business and sat down and allegedly engaged in gaming there. The businesses were open at the time. They were engaged in a brisk business, according to these affidavits. And Judge McDonald observed there is nothing set forth in these affidavits that couldn't have been obtained from interviewing a patron of those internet cafes or a former patron. There is nothing about the content of the affidavits, as far as we understand them from Judge McDonald's order, that rises to the level of good cause, that there would be some kind of threat to the investigation from revealing them.
I think I understood your brother to say that these affidavits would give information about the investigative techniques. They would give information about undercover procedures and so forth. You dispute that?
Your Honor, I'm at some disadvantage in the sense that I have not seen Mr. Ralph's affidavit, which is filed under seal in court, as to what those techniques might be.
You've seen the search warrant affidavits, haven't
I
you?
have not seen the search warrant affidavits, no, Your Honor. They have not been disclosed to us. They were offered to us. The appeals court granted the Commonwealth leave to give them to us, but the Commonwealth offered them to us on the condition that we agree that we as defense counsel are prohibited from sharing them with anybody except our clients and experts. We would not be able to share them under the Commonwealth's view of our confidentiality obligation with any third-party witness. And as a condition of providing these documents to us, they asked us to agree that we are so limited. We are not inclined to so agree. Our clients have now been indicted under very serious criminal offenses. And for us to get these documents now, we would have to...
Let's assume, yeah, so you filed a discovery motion, I assume, in the criminal case, or will, seeking the same information.
So were we to file a discovery motion in the criminal
case.
case, seeking the search warrant affidavits?
Yeah, I mean, the court could well order disclosure with some limitations.
Well, there is a procedure under the criminal rules, I believe it's Rule 14, that allows for restrictions on cause shown based on a balancing test. That is not what's before the court here today, of course, because these are publicly filed court documents, but documents filed in court that are subject to a presumption of openness. And unless there was good cause shown before Judge McDonald, that impoundment ought to be lifted.
So what did Judge McDonald have in front of him? He could look at the search warrant affidavit, and he could look at Mr. Ralph's affidavit. Was there
Yes.
anything else on the AG's side that he was looking at?
As far as he had the AG's arguments in opposition to our motion to terminate impoundment, and as far as materials, evidentiary materials, that was what he had. He had the search warrant affidavits and Mr. Ralph's affidavit. Notably, he gave them the opportunity to file any supplementary affidavit they wished to file in addition to the Ralph affidavit, but they chose not to file one.
And while we're on the subject of affidavits, what about the Attorney General's point that there was a complaint made repeatedly that your allegations were not supported by anything verified?
The complaint set forward the facts as we alleged them to be. We attached copies of the search warrants. We have the search warrants, not the affidavits. And we set forward certain other materials that we thought were relevant to his decision. There was no understanding on our part at the time that we were required to file an affidavit in support of a motion to terminate impoundment. There's no case or court rule that the Commonwealth can point to requiring such a showing in this kind of sui generis proceeding. The Commonwealth, the important point is that the Commonwealth had ample opportunity to review our statements, and the statements made in this complaint was not so controversial that the judge, in his discretion, couldn't have decided he didn't need an affidavit. And that is apparently what he decided, having reviewed the Commonwealth's opposition.
Do you agree that it was a point of contention at the hearing?
I do not believe it was a point. I do not remember that it was raised at the hearing. I'm not saying that it wasn't. I haven't reviewed the transcript with that in mind. So I would have to rely on the record. The transcript is in the record in the record appendix. I do believe it was raised in the opposition brief that was filed on the day of the hearing before Judge McDonald. But at that point, the Commonwealth argued the motion, and Judge McDonald said, here's what I'd like to do. I'd like to get the search warrant affidavits. I'd like to get any materials you, the Commonwealth, would like to submit, and then I'll either decide the case on the merits or I will call for a further hearing. At no point did the Commonwealth then object and say, Your Honor, we disagree with that procedure. We think that first there ought to be affidavits filed, or we think that there ought to be some more formal answer filed at that point. They agreed, sure, we'll file these materials and you can make a decision. There was no dispute at that point. The important point is that the Commonwealth had every opportunity to dispute what we said in our complaint by its own opposition or by filing any supplementary affidavits that it wanted to do so, and would have the advantage of being able to do so under seal so that we couldn't even respond to it. It didn't do that. The judge properly treated these assertions in our complaint as undisputed.
Did the judge have the opportunity, or did your complaint say, if you will not make them public, at least make them available to us so we can challenge it?
Our memorandum of law, as I recall, did say there is this line of cases under the Fourth Amendment that provide a right of access to the target of a search. Please provide these documents to us so that we may review them and make a determination as to whether to challenge the probable cause determination. There was no case law in this state that we could rely on asserting such a right of access, but we think that it flows from the Fourth Amendment principle that the whole reason we have a Fourth Amendment is to allow persons who have been searched to challenge that exercise of government authority.
Can
and
I
without
ask-
the affidavit, they couldn't do so.
On that question, there seems to be, and I haven't done the research other than reading these, I mean, just reading the briefs in a couple of cases, but is there really a very definite split in authority on the application of the Fourth Amendment to pre-indictment, availability of pre-indictment affidavits and materials?
Yes, I would say it's fair to point out that there is a split of authority. I think Judge McDonald
Does
said
it
so.
weigh one way or another?
It depends how you look at it. There are 3 published federal district court decisions suggesting that there is a right of access pre-indictment. There is 1 unpublished federal appeals court decision suggesting that there is a right. There are several unpublished district court decisions suggesting that there is a right. On the other side of the ledger, there is 1 published Seventh Circuit case suggesting that there is no such right, the In Re Eye Care case.
Right.
That case notably was decided in 1996, and many of these district courts have looked at it and found it to be completely unpersuasive. Then there are a couple of unpublished district court opinions that go the Commonwealth's way. And then there are a number of cases that discuss this issue in dicta, including a published Fifth Circuit case that did not actually decide the Fourth Amendment issue, but that said, well, we think that the Seventh Circuit's view is reasonable. So I think it's difficult to tally up the relative weight of these authorities. I think that the more important thing is the extent of the analysis given in these federal cases. And I commend the Court's attention to the District of Maryland case. These cases are not very memorably named. It's the in-race searches executed on April 26, 2004, I believe. And that case really goes through the history of the Fourth Amendment, the purpose of the Fourth Amendment, and makes the practical arguments and the practical statements as to why such a Fourth Amendment right of access to these affidavits is necessary. The Seventh Circuit case, their strongest case.
Could I just ask you about that? Is
Yes.
that really, is it focusing on the target?
Yes, completely. And in fact, those Fourth Amendment cases suggest that there's some tension. There could be some tension in some cases between the public's right of access to these documents and the right of access to the property owner. Because I think, as you, Justice Gantz, pointed out, there may be some cases where a property owner would want these matters to remain impounded, but still wants access to them so that they can challenge the probable cause determination. Here in this case, we sought to unimpound them simply because we did not believe that unimpounding them would harm our Sixth Amendment rights any more than they were already being harmed by the fact that these searches were publicized and the Attorney General was issuing press releases calling our client's business a scam. So these cases really do focus on the rights of property owners and the serious implications behind a rule that says that you as a property owner have no remedy if your property is searched, but you're not indicted. The Commonwealth's whole premise on this Fourth Amendment question is that someone whose property rights have been invaded, whose privacy rights has been invaded, has no remedy between the time of the search and the time of the indictment. Here, in this case, 7 months. In that interim period, businesses can be destroyed, reputations can be destroyed, property rights can be seriously impaired, and in our case, $109,000 of our clients' money has been frozen in bank accounts pursuant to these search warrants without our clients having any idea what the probable cause showing was to the judge who issued these warrants. So I see my time is expiring. In conclusion, I would simply resubmit. Judge McDonald did not abuse his discretion. The impoundment orders ought to be lifted. Thank you.
We take a brief recess.